Now, I am going to dictate a legal passage at the rate of 120 words per minute. 5, 4, 3, 2, 1, start. Let's start. This appeal arising out of a simple suit against the railways for compensation for non-delivery of the goods consigned has involved several questions of law. The suit was filed on 27th to 1962 in the court of the subordinate judge 24 Parganas on the allegations that a consignment of several drums of caustic soda booked on 18/9/1948 for and on behalf of the then province of West Bengal at Katapukur railway station for carriage to Riang railway station to be delivered to the quinologist of the government of West Bengal in Mangpu district, Darjeeling, was never delivered. The learned subordinate judge who tried the suit dismissed the suit on 3 grounds. The first ground was that the suit having been filed by the state of West Bengal against the Union of India could be taken cognizance of only by the Supreme Court in its original jurisdiction. Under Article 131 of the Constitution, the second ground was that out of the 4 railways sued, in this case, no notice of claim under Section 77 Railways Act was sent to 3 of them, while the notice sent to the remaining railway was bad, not having been addressed to the proper officer, and the third ground was that the contracting railway not having been sued, none of the railway administrations sued in this case could be held liable, as there was nothing on record to show that the loss occurred on the railway of any of them. The issues relating to limitation was however held by the learned subordinate judge in favor of the plaintiff appellant. The state of West Bengal and the dependent Union of India has filed a cross objection on that score. Mr. Sudhir Bose, the learned counsel for the plaintiff appellant, has firstly urged that the learned judge, having held that his court had no jurisdiction to try the suit and that the suit was exclusively triable by the Supreme Court in its original jurisdiction under Article 131 of the Constitution, ought to have straightway returned the plaint for presentation to the proper court without trying and dismissing the same on merits. The contention of Mr. Bose could have merited consideration if the suit was really triable by the Supreme Court in its original jurisdiction. Under Article 131 of the Constitution as held by the learned subordinate judge, the relevant portion of Article 131 reads thus: subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute within bracket small a between the government of India and one or more states, or within bracket b between the government of India and any state or states on one side and one or more other states on the other, or within bracket c between 2 or more states if and in so far as the dispute involves any question within bracket whether of law or fact on which the existence or extent of a legal right depends. The learned subordinate judge, having decided the suit in 1965, his attention could not obviously be drawn to the decision of the Constitution bench of the Supreme Court in State of Bihar versus Union of India, where the Supreme Court clearly ruled that this much is certain, that the legal right which is the subject of dispute must arise in the context of the Constitution and the federalism in it sets up. In the instant case, the dispute relating to the legal right of the state of West Bengal to sue for compensation for non-delivery of the goods consigned was not a dispute arising in the context of the Constitution and the federalism it sets up, but was merely a dispute arising from the local rights of a private consignor of the consignee of goods. Stop. Thank you.